And we're going to skip from, we're going to Delegate Valderrama, 887. We'll come back to the comptroller's bill when she gets here. Delegate Valderrama, yep. Do you have a panel?
Yep. We'll wait. Good. Good afternoon, Mr. Chairman. Prayers for our Vice Chairman and esteemed members of the Economic Matters Committee. For the record, Chris Valderrama here presenting on House Bill 887. My panel is here with me. I submitted this legislation at the request of the Maryland Association of CPAs. So it is supportive by them and many others, not just here in Maryland, but throughout this nation. So with that, simply put, House Bill 887 ensures that actively licensed CPAs from other states can continue to practice temporarily in our great state, provided they have passed the Uniform CPA examination. Nationally, CPA licensing jurisdictions are exploring many new pathways to becoming a certified public accountant. And many states are considering alternatives to the traditional, for those who may know, the 150-hour education requirement, such as experience-based models. And at the same time, the Maryland Board of Accountancy is actively discussing alternative pathways to attract a more diverse population to the CPA provision here in Maryland. So as these discussions evolve and other states modify their licensure requirements, this legislation ensures that licensed non-resident CPAs who can currently practice now temporarily in Maryland under practice privilege provisions can continue to do so, serving Maryland businesses without disruption. So this afternoon, you will hear from the Maryland Association of CPAs, who will further highlight the importance of this measure. And so with that, I would urge a favorable report on House Bill 887.
Thank you, Mr. Chairman, members of the committee. Nick Manis here representing the Maryland Association of Certified Public Accountants in support of this bill, and we thank Delegate Valderrama for introducing it. The Board of Accountancy came to our association and asked us to put this bill in with our approval. We were supportive. They got past their deadline to put it in, and simply put, what it will do is continue to allow out-of-state licensed CPAs that are substantially equivalent to Maryland's qualification to continue to practice. As Delegate Valderrama said, we passed, and you know you've been down here too long, when I worked on passing the 150-hour requirement, which was very contentious in passing. Now states are moving away from that to get a more diverse group of candidates for CPAs and going to a more experienced model. Maryland hasn't had the opportunity to look at that yet, but other states are doing away with it. So for them to continue to look to be substantially equivalent in Maryland, this bill would enable them to do that. To my right, and will testify next, is the CEO of the Maryland Association of Certified Public Accountants, Rebecca Olson.
Thank you, Chairman Wilson and members of the committee. My name is Rebecca Olson. I'm a CPA and the CEO of the Maryland Association of CPAs. Founded in 1901, MACPA represents nearly 9,000 members throughout the state who provide essential services to countless individuals and members, businesses in Maryland. I'm here in support of House Bill 887, which modernizes Maryland's Accountancy Act to protect CPA practice mobility. Currently, CPAs licensed in other jurisdictions can temporarily practice in Maryland without a Maryland-specific license, provided that they meet certain qualifications. This mobility provision is critical for the CPA profession and Maryland's economy, as it allows businesses and residents access to the expertise that they need. Workforce challenges and rising education costs are leading jurisdictions across the country to introduce additional licensure pathways that will allow for practical experience to substitute for advanced education. Without updating our statutes, Maryland risks restricting CPA mobility and creating unnecessary barriers for Maryland businesses and residents. 887 addresses this by ensuring that CPAs licensed and in good standing in their home state can practice here temporarily. 887 keeps Maryland competitive, supports economic growth by ensuring timely access to financial expertise, and aligns our statutes with evolving standards. Finally, it safeguards and consumers by retaining the Maryland Board of Public Accountancy oversight. On behalf of the CPA profession in Maryland, I respectfully urge a favorable report for House Bill 887. Thank you.
I'm seeing no questions. I believe there's one other person, Gavante Hawkins. Giovanni Hawkins? Okay. Well, I don't see any questions. Thank you for this panel and for this bill. We'll
Thank
move
you,
on to
Mr.
the next
Chairman.
bill. Thank you.
Thank you.
Thank you.
Moving on to House Bill 842. 482. Oh, I'm sorry. Madam Comptroller, I didn't see, I saw you, I just didn't recognize you, that's weird. So that was awkward. I know, I probably could have said that differently. And I know you do have a panel, if you could bring your panel up.
It's just me and my team. I don't want to take up too much of your time. This is my first time here, guys. So exciting. Usually they send me to Ways and Means, so. Yeah, I'll tell the chair you said so. But good afternoon, Mr. Chairman, members of the committee. Thank you so much for having me here today. For the record, I'm Comptroller Brooke Learman. I'm here to ask for a favorable report for House Bill 577. So one of the lesser known responsibilities of my office is to enforce the business license requirements found in the Business Regulations article. Basically what this means is that our Field Enforcement Bureau, FEB, is tasked with going into businesses such as gas stations or convenience stores to make sure that their traders' licenses are up to date. And I have Van Howarth here with me, who is our director of FEB. Now, the Business Regulations article requires businesses to have a license to sell goods. And it does that because it gives those businesses the legal authority to operate and helps to ensure that the business remains compliant with state law, including, of course, their obligation to remit their sales taxes. So if we want to have funds for schools and roads and whatnot, we need to collect this revenue, and we use these licenses as one of the ways to incentivize businesses to pay the taxes owed to the state. If a business operates in violation of state law or fails to pay taxes, they don't get a license, and they might be criminally cited. So, over the past 2 years, I've learned a lot about our agency, the good, the bad, the ugly. The good part is that our field enforcement officers make every effort to avoid issuing citations unless it's absolutely necessary. They make repeated visits to businesses and work to educate those businesses about their legal obligations and help those businesses get into compliance. But one of the ugly and bad things that I've learned is that under the law, when an agent goes into a store and there's no business license, our agent can issue a citation to any person working at that store. And it's not just any old civil citation, it is a criminal citation. So in other words, if some 18-year-old kid who has a summer job as the manager of a local convenience store has no authority over whether that store has a business license or not, he or she may find themselves served with a criminal citation because the person responsible for that store and responsible for getting that license, is out of the store or whatever and didn't keep their license to sell up to date. I think this is terrible and unnecessary. First, it means we could be issuing a criminal citation to someone who isn't responsible for even having the license. And that person then needs to go to court to fight it or pay a fine or even risk jail time. Second, the goal of the enforcement system is to curb unlicensed activity, but it doesn't help to issue citations to workers in the business who have nothing to do with the business license. So it's ineffective. So I'm asking you to do something today that elected officials rarely ask you to do. I am asking you to give my agency less authority. I am asking you to fix this so that my agency can only issue citations to the people who can actually get a license and be responsible for that unlicensed activity. That's what HB 577 does. Rather than using the broad language that says any agent who is individually subject to penalties, we're proposing a narrow list of the parties who may be cited in these cases, parties who actually have some authority over the business license. That, quote, license representative would be identified by each business on their license application. That way, my office will know who has the responsibility and can focus its enforcement where it will make a difference while protecting Marylanders. I also want to add that we've been in discussion with the Maryland Chamber of Commerce, the Maryland Retailers Association, and other groups who've had questions about the language. It's sort of complicated. If you just look at it on the face of the bill, it's not really clear what it does at all. So they've had lots of questions and want to ensure that it's not difficult for certain types of businesses to comply. We're totally fine with that. We're happy to make sure that this bill applies to businesses only with a brick and mortar location in the state, and we're happy to get you some sponsor amendments to take care of that. We're also happy to continue working with the Chamber and other stakeholders to ensure we have a process that safeguards workers without unduly burdening businesses. Thank you, and I urge a favorable report on HB 577. Any questions?
Did anybody else in your panel want to speak? Or?
I don't think so. I think we're just here for questions.
Delegate Adams first.
Okay. Thank you, Mr. Chairman. So with the, I'll just start with a LLP or a limited liability company. The resident agent is not discussed here. So why are we not sending notice to the resident agent?
So we would be happy. So the resident agent, basically, they're one of the people that could be cited, but we can't send them out of state. So the resident agent is in the state usually, and we're happy to have the resident agent be the person, the person who is responsible for the license. If that's what works for businesses, it can be the same person, but we just need to know that. So we need, because sometimes it won't be. Like there are many businesses that have incorporated, and they won't want their resident agent to be the person who is responsible for the license. They might want it to be different. So we want to give businesses the opportunity to tell us who's responsible for the license. If it's the same as the resident agent, that's fine. If they want it to be somebody different, that's fine too.
The resident agent is the individual who's responsible for receiving these sort of communications. I would say citations go to the resident agent. They don't go to the members. And in the case of an LLC, I mean, you've got members that are obviously limited members, limited in liability. So you're suggesting under the bill that one of those limited members could be named as the one receiving the citation.
We're not suggesting anything. Okay. We are just asking for businesses to pick anybody they want to be the person responsible for it. So and keep in mind, this is only for businesses that need to have a trader's license, right? Many businesses operate in Maryland, lots of LLCs that don't have a trader's license, they don't sell. So this is primarily retailers, it's not even wholesalers. It's retailers and wholesalers who buy and sell goods, but not wholesalers and growers who don't. So it's not every business, right? It's a subsection of business.
So you're saying this bill would only apply to trader's licenses?
Yes, just trader's licenses.
So I just to make it personal, in my business, yeah. I have a MHIC license, that's mine.
Right.
This bill doesn't apply whatsoever to that particular license. No. So you're after a very specific, narrow.
Very specific, very narrow set of licenses. Yes, businesses, exactly. Thank you for clarifying that.
Yeah, okay.
Yep.
Okay.
Thank you, Mr. Chairman. You have the authority to issue citations now or no?
We do. This is part of what our job is. We go
because
in
and that looks like it's being added as a
I know. It's very confusing how it is written, which is why I wanted to start by saying one of our duties is that we already have the authority to issue these licenses. Our concern is that we can issue them to people who aren't responsible for getting the license.
Not the license, the citation.
issue citations, right, sorry, thank you. We are already responsible for issuing citations to businesses that are required to have traders licenses. The problem is that we are expected to issue those citations to somebody that we find, even if it's somebody who is not responsible for getting that license. And so we want to curb the authority of the agency so that we are only issuing citations are only able to issue citations to somebody who's responsible for getting the license, not some kid who has like a summer job.
Okay. And then I heard you say you were working with some folks, but NFIB says that the bill isn't necessary, that you can already have this authority through your rulemaking process to require information that's needed. Is that true, or is that something you were working on?
We wouldn't have brought the bill if we didn't think it was necessary.
Okay.
Yep, thanks.
Okay, thank you.
Thank you, Mr. Chair. Why the carve-out for other businesses, including growers?
Carve out.
Well, you carved them out. I mean, they're not applicable to this bill. You just said that they weren't applicable to the bill.
Because they are not they're not required to have a trader's license.
So why only the trader's license?
Because that's the license that, that we enforce. We don't, so we enforce trader's licenses. That's already in state law.
Right.
And we issue citations, criminal citations to people at businesses who are operating without a trader's license.
Okay.
That's our authority.
So
There are
you-
many other businesses but we don't have that authority. We work on trader's licenses. That's our authority as an agency.
Okay.
Yeah.
So the comptroller's office is just strictly for the traders, the retail shops. I'm no
Right.
longer a retailer, but just the retailers.
Yes.
Yeah.
Yes.
Okay.
Which is why we've reached out to Maryland Retailers Association to work with our alliance to, yeah.
Thank you.
Yep.
Only because I can't. So who are these two young comptroller employees?
Oh, yeah. Sorry, it is a snow day today. So I have my son Teddy in the blue hoodie and his friend Max in the nice plaid button up. So this is their first time in ECM too.
So my wife is with our kids in court today. So,
There you go.
Shout out to all the moms out there.
Yes, yeah. They got to go to BPW this morning too. Yeah, that's right. Yeah. Good one.
I might have missed this, but when I've signed for my license, I sign my name's on it.
Yep.
I guess I'm a little confused. Don't you have that name already on
So-
all licenses, or don't I have to put a name to it?
We do have that name, but we are allowed and expected to go to issue a criminal citation to anybody we find, even if it's not you. So what we're saying in this bill is, if you're the person responsible for getting the license, just tell us, we can only cite you. Not that we can cite the kid who you've hired for the summer.
Okay, I guess I get kind of odd. I would expect you to cite me anyway, only me, not somebody else.
I know, you would expect that,
saying-
but that's not what the law has. That's not what the law
You
says.
can cite anybody.
The
and this
law
is
says
trying
we
to
can
firm
cite
that up, that
everybody.
You can only cite me.
Yeah, I know, it's like very crazy, but we're trying to limit our authority here. Yeah.
Thank you.
Yeah, absolutely. Great.
Thank you. Thank you, Mr. Chair. I might have missed this when I had to go back this way.
No problem.
On the phone. But did you say how many citations did you put out? There was a reason why y'all are going after just these trader licensed people. How many have you found out that it was more than what y'all thought it was? So now you know you really have to go and cite these people. You found out all of a sudden that you got over 50 or 1,000 of them to go after?
We do issue a fair number of criminal citations. I don't know how many we issued last year. Do you know how many we issued last year?
It's about 100 a month, so about 1,200 a year.
About 1,200 a
About
year.
1,200 a month.
1,200 a year, 100 a month.
year.
Yeah. Yep.
okay.
So, not nothing, but, great.
And did I miss the fine?
It's a criminal citation, so it's, I think, up to $300 or up to a year. 30 days. 30 days in jail.
30 days in jail. Okay, thank you.
Yep. Great. Thank you.
Thank you very much.
Thank you.
Seeing no further questions for this panel, we will move to the favorable with amendments. Thank you guys very much.
Thank you so much, Mr. Chair and committee.
Thank you.
Thank you.
We have Grayson Wiggins.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce. I do want to thank the Comptroller's Office for meeting with us a few times prior to the hearing. We are still working with their office to try and find some amendments regarding the language and the questions that that language has raised in our previous conversations. You have our written testimony, so I'll be quick. I do just want to highlight two specific provisions in the bill that we have questions about. The first is on page 2, line 9, which requires the licensee to identify a resident of the state. So Title 17 of the business regulation article includes a number of different licenses, some of which are inherently non-resident. And I'll give you an example. 17-601D is a non-resident construction license. And so this would be placing a new requirement on those types of businesses who provide some services to our members by requiring them to have an actual resident in the state. The second issue that we wanted to raise is on page 3, line 18, which seems to remove the language and the requirement that the individual who is convicted actually engaged in the unlicensed business. And so we're unsure as to why that language is being removed, if the intent is to try and identify the person who is responsible for the unlicensed business. But again, we are working with the Comptroller's Office, happy to continue to have conversations with them and try and find some amendments that can answer these questions. Thank you, Mr. Chair.
Thank you. Seeing no further questions, we'll move on to the unfavorable.
Good afternoon, Mr. Chair and honorable members of the Economic Matters Committee. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Alliance. We are unfavorable, but I do want to thank the Comptroller's Office. As you heard, we have been in conversations with them about this bill. I'm definitely not here advocating to be in non-compliance at all. I just want to make that clear too. But thank you, Delegate Adams. You got to the crux of what my issues have a problem with here, which is we already have to have a registered agent. And that individual has to, by law, be available during normal business hours to receive compliance. So we actually think the fix here is probably to designate that person to receive these citations. Our members just felt like this is another hoop we have to jump through, identify yet another person who, by the way, would have to be a Maryland resident, which Grayson brought up earlier, which may not be appropriate here. Folks live across state lines, or perhaps the highest ranking individual in one of our regional companies is a manager, and that person is also not the most appropriate person to receive a citation. I just want to correct this on the record, and if you look at the fiscal note, this is on page 2. This is not just about traders' licenses. This bill applies to 15 categories of miscellaneous business licenses, including construction licenses, junk dealer, scrap metal processor licenses, restaurant licenses, traders' licenses, and vending machine licenses. So because that had come up, I just wanted to make sure folks on the committee understood that. We are glad to work with the committee and the Comptroller's Office to figure this out. So thank you.
Right, so I guess I'll follow up on that. And when I read the bill, should the bill pass, I mean, I'm imagining someone wanting to be in compliance with this who's a limited member in a limited member in a limited liability partnership who theoretically would be agreeing to or being responsible for a criminal citation, which goes at the heart of what an LLC or an LLP is. I mean, the management structure of an LLC and an LLP there's a reason why that exists. It allows for investors and others to participate, but not in the management. It's to participate financially in the benefit that comes from having that ownership. But correct. To say that anybody who would be a member of a partnership like that would have some ability to take ownership of this sort of criminal citation, I mean, I've got real problems with it. Not because I think I know. I mean, I think I would know as a limited member not to sign or agree to participate in this, but how many people, if this bill passes, would feel compelled and/or say it's no big deal until it's a big deal? I mean, that's the concern I would have with a bill like this. I assume that's the testimony that you're bringing. And I would be very concerned if we pass the bill and not give proper guidance to everyone. It's why there's a resident agent, right?
Correct.
I mean, a lot of bad things can happen in a C corporation, an LLC, a limited liability partnership, whatever that looks like. A lot of bad things can happen. And all those bad things, whether it's a lawsuit, right? You get sued. I mean, that has to go to someone who's responsible for receiving, not only receiving the communication, but making sure that the company is served. That's the whole reason behind the resident agent. And I don't know, with respect to the comptroller, I'm sure there's a good and rational reason for the bill, but it seems like it's causing people that don't necessarily think about this every day to just say, oh, you know what? Yeah, sure. And then realize all of a sudden what they just did comes with some major implications. I'm surprised and concerned.
Absolutely. I mean, we agree with the premise here. We don't want them to come into one of our stores and issue a citation, a criminal citation. That's a misdemeanor, by the way, to a cashier. That doesn't make sense either. But corporations, LLCs, no matter what the structure of that company is, have already designated a registered agent. And that person is going to be the most applicable, what we think is the most appropriate person to go ahead and give this to. And I'd also say, I think of grocery stores a lot in this committee, and we already have about 30 different licenses that we have to pull. And we don't want to have yet another person and another license that we have to jump through hoops on and identify somebody else on that. So we really feel like if we focus on registered agent here, we could probably solve this problem.
Right. I mean, and I'm just additionally thinking, a C corporation. So I'm involved in the C corporation. There is the corporate veil. I mean, there is the separation between the entity. I mean, that's an entity and the individuals that operate it. And I mean, unless better explained, it seems like they're trying to get around the legal structure and why the legal structure exists for enforcement. And again, I'd have to have better examples of what they're trying to get at and who's trying to evade them to get at it, because the vast majority of people that this is going to affect are just the average citizen that is a business owner or participates in a ownership structure that may someday, because of this bill, have to show up in court over a criminal citation. I mean,
Thank you, Mr. Chair. I'm confused. Can I just back up for a second? Are you in agreement with the fact that right now, the way the law is written, the officers who work on enforcing this can show up and issue the citation to anybody who happens to be there?
That is correct.
The kid who's working a summer job?
Yep.
Right, that's what it is right now?
Correct.
So we're not adding new citations that are getting distributed, is that right?
That is correct.
Okay, what we're trying to do is to say, when you're enforcing the law, there's a limited number of people you can enforce it with.
Correct.
Right? Okay. So I'm just a little concerned because I feel like some of the questions are suggesting that we're adding the ability to cite. We have the ability to cite.
Correct.
Right now, it could be the kids scooping ice cream for the summer.
The question
right?
is,
I'm thinking of that because my son did that
cite?
a number of summers. We all agree it shouldn't be my son scooping ice cream for the summer.
Definitely not.
Or anyone else's. It should be me. Okay, we got that. So then the question is, who should it be? And I'm just trying to understand if your testimony is that instead of naming someone, it should just automatically be the resident agent? Is that what you're saying?
That's when we had a conversation internally with our members. We have already designated somebody who has to be available for correspondence during normal business hours.
Okay, and so is your testimony that it is burdensome to on the piece of paper when you're already filling out a piece of paper or online for your application?
Correct.
Like you have to do a trader's license.
Yep.
And this would suggest there's one more line on the trader's license where you would put the name of the resident agent in.
Right.
And that's what's burdensome?
Well, it's on a yearly basis, we have to apply for a trader's license.
You're doing that anyways. This doesn't change
We have to
that.
do that. That's
Okay.
correct. But identifying a Maryland resident every year may not always be appropriate, so that was one of the problems here.
Okay, can I just ask you about that, though?
Sure.
I'm actually trying to understand. I'm not trying to argue about your position. I'm trying to understand. So the resident agent has to be a Maryland resident, though, don't they, or don't they?
No, they do not.
Okay, so I think maybe that's the problem, because for the citation to be issued, it has to be issued in person to somebody who is physically in the state, right? That is, I think, the problem, because they don't have jurisdiction to go find the resident agent in Florida.
They have to be available for correspondence, though, during normal business hours. So they may not be a Maryland resident, but they have to be available in Maryland for correspondence.
But if a citation is issued in person, that's why my son scooping ice cream is getting it instead of the resident agent in Florida, right?
Technically, sure.
So I think we would have to change kind of the rest of the law to have a citation, to have officers from Maryland showing up in Florida issuing citations.
Right, which is not going to happen.
Yeah. So, okay, I think I understand what you're saying. You want to have citations, you're talking about changing the fact that citations are issued in person to someone in Maryland. Because your resident agent could be somewhere else.
Technically, they could be, but under Maryland law, they are supposed to be available for correspondence
But not in person.
Here. Yeah, I would have to look at it again, actually, because I'm not sure now.
Because I think if the resident agent is available in person, that would just be the name that you put on the license, right? And that, I mean, yes, it's one more line on a piece of paper, but I don't think that's overly burdensome. But I think the concern, if I'm understanding and following what the bill is doing, is it's got to be someone in Maryland. So it could be the manager of the store, it could be the resident agent, it could be anyone, but because it's an in-person citation, it's got to be someone in Maryland.
Right.
Yeah. Okay, so you're saying you want it to not have to be someone in Maryland, is that?
No, we don't want them, so first of all, we don't want them to have to be a Maryland resident because that may not be appropriate, and I think I've explained that.
Okay, resident, no, but physically available and
They need to physically be available in Maryland.
to be able to receive the citation.
Correct.
Okay, so it's the word resident as opposed, it's like legal resident as opposed to
Is
physically.
one of our problems here.
Okay, so it does sound like maybe there's, I mean, you're still working with them, right?
Yes, we are.
Okay.
Yeah.
All right, but it has to be someone physically here, otherwise they're going after my
Correct.
son scooping ice cream.
And there's no jurisdiction. Understand exactly what you're getting.
Okay.
Got it.
Got it, thank you.
Thank you, Mr. Chair. So page 3, lines 11 through 13, it says, for a business entity not identified under items 3 through 5 of this subsection, one or more individuals who manage the business and affairs of the entity. Well, that could be an 18-year-old that's taking care of the small mom and pop grocery store. Because what's the definition of manage the business? To a business owner, that might be true and proper running of cash registers and checking out.
It could be an 18-year-old that's the manager standing there that day overseeing 2 other employees, sure.
So I guess what I'm getting at is from a legal perspective, where in this legislation does affairs of the entity start and stop? So we would have to bifurcate.
See, I would say that probably needs to come out then. We need to do a better job here in talking about who it is that we're identifying and who can be issued the citation, because that still leaves it open.
Okay, well, that's what the legislation says. So to me, as a former retailer, I mean, Jerry, who worked for me for 10 years, was in charge of ordering, and this person called, and this person, is looking for, an open invoice you have to be, and also to so-and-so stopped by, a rep stopped by, this stuff, and then ringing out his register and making sure that's accurate. So to me, that falls under the legal terminology of the affairs of the entity. So he could technically still, even though I'm the owner and the resident agent and the whatever, I mean, I'm not anymore, but he could technically still be issued the citation. Or so could Duncan when he worked for me at 20 years old before it became 21. You know what I mean? So, or better yet, Lorig. I mean, we could just.
I'll just take all the citations.
All joking aside, I'm being serious.
I
so,
understand.
Yeah. Okay. Thank you.
Delegate Adams?
Yeah, I'm back. Thanks for a second bite at the apple. I just got off the phone with a business owner that I know and got on the phone with that company's secretary that does all the licenses for this C corporation. Okay, many, many licenses, all right? Because it's process. It's pay a bill, pay a fee, and move on, and it gets done again in April, this trader's license. And I asked this secretary who does all these, how would you feel if one day we pass a bill up here in Annapolis and you subsequently get a criminal citation and that individual hung up on me? All right, so what I'm saying, if I'm saying anything, and this is just not a simple bill right now, this is a process. People get licenses all the time, and the owners are not the ones that show up, go online and get licenses. People in the company that are responsible for helping it get run make sure the licenses are up, okay? And this bill will pass without proper notice to everyone that's a business owner in the state of Maryland, to warn them and encourage them, hey, look, the next time you fill out a trader's license, by the way, just don't hand it to your secretary.
Right.
And I don't mean secretary as I'm talking about a secretary who's on my, secretary is a board position, right? But it is a ministerial job. It's a task. And that individual being handed a criminal citation because we up here in Annapolis want to pass a bill like this, now I've got a problem with the bill. Because not only do I want to know why this power is needed, but I want to know what outreach am I expecting the comptroller to give to all businesses that get these trader's licenses to forewarn them that the next time you fill out a trader's license, that individual is no longer just doing the
They're
job.
criminally liable.
They're
for
going to
any
be
citation.
criminally liable.
Right.
I guess my question just goes back to, if you want to have the resident agent be this person, like resident agents aren't people, they can be LLCs, they can be entities. So like who would be criminally liable if it's the LLC that's the resident agent? Because every business entity I've actually formed or advised, I can't remember the last time we had a resident agent that was actually a person. The resident agent was there was often a list of resident agents you choose from. So who would be criminally liable if you wanted to keep it as the resident agent, as the person who is the person that should report? Who's the person who's responsible as a person if it's an LLC? It's this resident agent.
In our conversations with our members, they were delineating a person. So, I mean, this is language that we're going to have to work on here. Our problem is we don't want to have to keep creating separate people and identifying separate people on a regular basis. They want to be able to say, this person is who's going to receive correspondence and citations on behalf of the company, and that's who you go to, period, done, instead of let's create something else here.
Got it. But I think, I hear you and look forward to more discussions on this, because I think this is more complicated than what we're making it. It's more complicated than we think as far as like the responsible person, if we're going to switch to the resident agent being the person. So, but I'm just trying to figure out how that would work criminally, but we can talk about it offline.
Got it.
That definitely concludes this hearing.
Okay.
Thank you guys very much. We're going to move on to the next bill now. We have Delegate Harrison, House Bill 848. Ooh, Jesus. 482, that is a dyslexia, something fierce. Wow.
Thank you, Mr. Chair. I did have a panelist, but I think he's going to be virtual because of the weather that we had and the opportunity to do so. So for the record, I'm Delegate Andrea Harrison, here presenting HB 482, which is a reintroduction of a bill that we passed out of this committee and this House last year. It just didn't get through the Senate in time. And so I'm here again. This is the occupational licensing and certification, and it is a predetermination bill. Basically, what this bill is saying is for an individual who may have had contact with the criminal justice system at some point, that once they have adjudicated, once their sentence has been completed, and they decide that they want to get a license of some sort, that they could go to whatever board it is to ask if their criminal history would prevent them from getting a license. That way, they would not have to spend unnecessary money and unnecessary time trying to get a license, only to be told at the end, after they've spent money, spent time, perhaps even passed the test, that they were not eligible. So I won't go through everything that I have here. You all have all of the information in your system, including letters of support and some unfavorable. And I would like to take a moment to address some of those, if I might. There is a racial impact study report that is there. We know that individuals of color, Black individuals in the state are incarcerated at disproportionately higher numbers than anyone else. And so this particular bill could be helpful to those individuals, helping to ease the recidivism rates that we could possibly see if those individuals are not able to get employment. There is testimony from the social work advocates that was listed as favorable with an amendment. They have an amendment that I would accept as a friendly amendment. Once I know that we have to get to that later, but I would accept that as a friendly amendment. And there were a couple of documents from organizations that were listed under the health department that were listed as unfavorable, and I would like to address that because in this bill, there is a section that says nothing in this section may be construed to override, supersede, or invalidate any compact or agreement that is already in place with regard to the regulation of any profession or occupation by a department, or supersede any authority of a department to require an applicant or a licensee to submit to a criminal history records review. That is most of the testimony that I seem to have seen from those individuals who are listed. I think that this addresses those issues. I worked with them last year, which is why we have the bill introduced the way that it is. It included those amendments. No one reached out to me with issues this year, so I was surprised to see those documents. Further, I have been attempting to work with the Department of Labor to try to address the fiscal note, which, by the way, I got at 10:40 this morning for today's meeting at 1 p.m. So there's absolutely no way to address a fiscal note that you don't know anything about. I'm going to put that out there for the record because I'm sure that each and every one of us are extremely frustrated by getting those fiscal notes so late and not having an opportunity to work on them. I will say that I am puzzled by some of the what is in the fiscal note with the number of individuals that these departments say that they would need to hire to do a predetermination. They have to determine whether or not these individuals would be eligible at some point. So why do they have to hire new additional individuals for a predetermination when they're going to either do it on the front end or the back end to determine whether or not someone is eligible? Why do they need to have additional people? It's not my area of expertise. They may have a good reason, but because I didn't get the fiscal note until 10:40 this morning, I couldn't ask the question. Finally, I would just say that I have operated in good faith with every party that has come to me to have asked questions. Oh, by the way, I was talking about the Department of Labor. They didn't get back to me, even though I called them and asked them for updates. So, and I know that at least one of their individuals is out on paternity leave, so I won't hold that against him. But it is, when you're working in good faith and trying to trying to do what is right. It is it's a little frustrating to get to this point, to not have all of the information that you need. So I know that I have gone on. I thank you so much, Mr. Chair, for your indulgence. And with that, I would ask again for a favorable report from this committee on HB 482. Thank you.
Thank you, Delegate. I guess maybe we addressed this last year. Have we gotten an answer as to why it costs so much more to do this up front versus after? I remember some allegations about, because let's say you're taking a class or certification, because half of those people will fail. Therefore, you're only, I guess, doing a background on the other half. That's the only, and that's very specious reasoning at best, but that's the only thing that I've heard. Seth, I'll tell you what that word means later. But I literally, have you heard any other rationale as to why it would cost so much more to do this before allowing these people to embark on this endeavor?
No.
Great answer. Okay, I believe we do have a few questions.
Thank you, Mr. Chair. So maybe this helps with that question, and I think it's a good one. So I was reading the testimony from the Board of Physicians, and they say they get about 8,000 applicants a year. And of those 8,000, there was about 163, I guess, things that popped up, related to the criminal stuff. And they said every single one of those person was actually approved for licensure. And so are they saying there's an additional cost because they would end up doing a predetermination and ultimately still having to do the full application after that? So it's 2 steps versus just the current 1 step?
Well, that's a good question, but no one has come to me to talk about that. And so the way that I understand, I don't understand what they're saying, quite honestly. Either you're going to do it on the front end or the back end. And all of these individuals are saying is, here's what I did. Here's what I've done to remedy this. Would this prevent me from ever getting a license? That's it.
Yeah.
That's it. To me, it's very simple. It's either a yes or no. Right. And if it is a no, if there's an opportunity for some additional level of remediation, then, they can share that. They would share that information with the individual. And then the individual would have an opportunity to come back at a later time, about a year later, and ask again if they have met those requirements. And of course, if anything happens where they have had another infraction, then they would immediately be disqualified.
Maybe just CC the chair on that next email to the department, and they'll get us an answer.
I think that's a very good idea.
I don't know.
Very frustrating to hear.
Thank you.
This was the question we all had last year, and I would have thought either way. And have you ever cross-filed?
No.
I don't know where you learned this from.
Yeah.
Trying to do it by yourself?
Yeah,
I'm just playing with you.
It is what it is.
No, that's fine. I think I just want to make sure that we figure out where assuming it makes it out of this committee, that we figure out where the sticking point is over on the other side as well, okay?
Yes.
Delegate Queen?
Thank you, Mr. Chairman. I think my question is all related to the cost. Was there a fiscal note last year?
There was.
And was it the same or was
it was a little less.
It was less, so.
Just a couple $1,000 less, basically. And I'm going to say it's inflation.
Oh, okay. So you asked that question last year and you just never got an answer to why it was the cost?
So last year, basically, it was just that they needed to have additional people to do this predetermination. So I don't know that I asked the question that way last year. I will admit that.
Okay, all right.
I may not have asked it that way.
Yeah, okay.
All right, we're going to we have a few virtuals. Chad Reese.
Thank you, Chair. Thank you, Chair Wilson and members of the committee for the opportunity to testify today. My name is Chad Reese. I'm a senior policy advisor here on behalf of the Institute for Justice. I also testified in support of this piece of legislation last year. In 2020, the Institute for Justice published a report called Barred from Working. That's a comprehensive study of the collateral consequences of occupational licensing restrictions for people with criminal records. That study uses 10 criteria to grade all 50 states and the District of Columbia on their legal protections for licensing applicants with criminal records. And just want to note that in that report, Maryland scored low, particularly on its due process protections for those individuals, in large part because of a lack of this type of predetermination process. About 19 other states in the District of Columbia have such a predetermination process. They're increasingly common. And since 2015, 38 other states and Washington, D.C. have in some way increased transparency in licensing for those with criminal records. To the previous question, which I think is an excellent one about the perhaps low rate of rejections for these licenses, I know that was an issue last year that the committee was interested in. I'll just note that one of the reasons that you do see low rates of rejection for criminal record licensing from licensing boards, and one of the reasons licensing boards typically oppose these types of bills, or a reason they give for that, is because many potentially rejected applicants never bother to apply in the first place, whether it's because they get bad information or they misread something in the requirements. A number of folks will assume that they don't comply and won't bother to go through the other steps that are necessary. By increasing transparency and providing this sort of predetermination process, you give them a lot of certainty and you say, well, why don't you clear up this hurdle first? And then if that makes sense, you can proceed with whatever other requirements the license has. So I think you also see an increase in participation in the process.
Thank you very much. Seeing no questions, move on to David Morgan.
Yes, thank you for the opportunity. Thank you for the opportunity to speak. Chairman Wilson, the ECM Committee, and I also want to thank Delegate Harrison for her continued efforts on this issue. One of the things that I want to make sure that I communicate is that when it comes to the fiscal note, I think it would be good for those licensing bodies to look at other states that don't have fiscal note when it comes to predetermination. You can customize that experience where it doesn't have to be a full hearing to accomplish that goal of predetermination. Some of those states, Delaware, Pennsylvania, Ohio, West Virginia, and even Virginia, where this bill has already passed the Senate unanimously and is already just passed the committee yesterday and is ready for a House vote. So there are several states that don't have fiscal note or very minimal cost for predetermination, and I think it might be prudent for Maryland, for those licensing bodies to see how those licensing bodies do it without a fiscal note at all to determine predetermination. And those are 25 states that are currently doing that. Thank you for your time. Again, Chairman Wilson and the ECM Committee.
And he was short.
Mr. Freeman, Jamel Freeman's next.
Hello there, can you hear me?
Yes, sir.
All right, my apologies with the video. I'm out here in Frederick. Good afternoon, Chair Wilson, Vice Chair Crosby, and members of the Economic Matters Committee. Thank you for giving me this opportunity to testify in support for the amend and add to rather than replace the current procedures. Thank you for Delegate Harrison for in support your advocacy efforts on House Bill 482. For the record, again, my name is Jamel Freeman, and I'm in favorable support of House Bill 482 with amendments to add to the current procedures, then replace. You already have my written testimony, which I have already submitted on Monday, but I just wanted to highlight a couple key contextual languages within the proposed legislation. So in 2023, I had begun the application process for my alcohol and drug training certification license. So with that, there was a lack of transparency in the processes of the occupational licensees. with an individual with a non-criminal history, as of the process cost me about 5 different job opportunities, which I could have had, and actually the cost of the application was $150. Now, if you go back to, and I reiterate, and I ask that the committee consider, and we should maintain the protections that are available for the people whose criminal history is over 7 years in the past. I urge the committee to not remove the current language of the status listed on page 3 of the proposed legislation, section 4, 2 lines 8 through 13. And in the previous House bill that was proposed last year, 0175, on page 4, 5 through 13, you will see in the brackets that it is missed. I just ask for a favorable support. My name is Jamel Freeman, and House Bill 482.
Thank you very much. Seeing no questions on this bill, thank you again, sir. That does conclude this bill hearing.
Thank you.
Thank you. We next have House Bill 559. Delegate Morgan. If you have a panel, you can bring them up.
Me. Thank you, Chair Wilson and members of the Economic Matters Committee. I'm Delegate Todd B. Morgan, here to talk about House Bill 559. I brought you one fun one last time. I bring you another fun one today. The purpose of the bill is to make it easier for ag tourism businesses to serve food and comply with state regulations on restrooms. House Bill 559 provides an alternative and more cost-effective way for these businesses to comply with these requirements and provide guidance to exist across the state. If anyone went to the ag luncheon dinner last week, you realize that agriculture is the biggest business in the state. And I'm now going to address the biggest elephant in the room, and that was what seems to be burgeoning and burdening ag tourism. All the agencies, health, ag, environment, and local health officers admit this is a problem, but no one seems to have the answers. There have been work groups over the last few years to discuss it without any result. MDA started a group called SIGA, Governors Intergovernmental Commission for Agriculture, which is not met. So the issue still has not been addressed. There is a need for bathrooms in hand washing areas, facilities in the areas that serve barns, fields, and other agricultural needs. These areas may not have access to running water or septic systems, or may it not be feasible to put in a permanent facility at these locations due to topography, land preservation, or costs. The construction of restrooms can pose a substantial financial burden on small businesses, especially when they're starting up. A cost for some of these septic systems to accommodate guests could range from $200,000 to $300,000. Some currently use portable chemical toilets, porta potties. However, this varies on a county-by-county basis, requiring the permission of the local health department with varying regulations in different counties. Under the current law, food establishments must provide convenient restrooms which meet certain regulations, including cleanliness and ventilation. Individual county health officers and health departments regulate how this works in their county. In my area, Calvert and St. Mary's County, they manage these things quite differently, and being a legislature representing both counties, I get caught in the middle. Calvert blames St. Mary's, why can they do this and we can't, and vice versa. The bill will hopefully smooth out inconsistencies that exist between the counties and provide a clearer framework for the small business owners moving forward to ensure patrons receive a quality experience without the establishment being unduly burdened by regulation. The bill is narrowly targeted to apply to only those ag tourism businesses, and I believe the bill is consistent with other changes in state law that we've made over the past several years to encourage the growth and success of these types of small businesses within the state. The Maryland Department of Health and MACHA have brought up concerns about not having pressurized water. It's my understanding that those executive portable chemical toilets not only have nice bathrooms, but full hand washing facilities, but also provide pressurized water. Another alternative to those with water on the premises is to allow wash stations to have direct hookup to the available well. These executive portable chemical toilets can be pumped weekly for around $200 to $300, keeping the area sanitary and free from environmental concerns, thereby addressing some of the concerns in the MDE letter. As ag tourism grows throughout the state, we need to address this issue not just to continue to kick the can down the road. We need a way to provide, we need to provide a way for the both parties and patrons and agribusiness can operate safely, and that's what this bill aims to do. I spent an hour this morning with MDH on this, trying to work with other stakeholders on the issues and hope that we can come to agreeable amendments or a series of amendments in the near future to solve these concerns. And I respectfully ask consideration for a favorable report on House Bill 559.
Well, as much as I appreciate your economy of words, in just like a sentence, what do you want this bill to do?
What we want to be able to do is we want to promote ag tourism in such a manner that we have to worry about where the portable bathrooms are and how we can wash our hands at them in a sensible manner.
So do you just want to have portable bathrooms and hand washing stations in these agritourism areas? Is that what you're asking?
The state basically requires in many instances to have those in these instances.
Okay.
Some are little small mom and pop places. They can't afford to put in a big well and septic system.
Sure.
Some can't afford to put them in, so they're going to have to do it. The problem I'm running into as I look at this across the state, and ag brought this to my attention, is that Mako make a comment that the locals want to have authority and control. I get that part, being a small business guy in a small county. However, when you have different health officers implying different sets of rules, the problem becomes that it's inconsistent across the state. I'm just trying to tighten it up a little bit that allows these small ag businesses to be able to operate effectively and efficiently using a porta potty or a hand washing station.
So that sounded like a very long yes to my question.
Whatever you say, you're the boss.
I'm so confused. You want these small businesses to be able to have portable bathrooms and portable hand washing stations. That's what you want to do, stations?
Yes.
Right?
Correct.
Whew. Okay. I got you. I was Delegate Adams.
I mean, if it's simple as that, I'll vote for the bill. How about if so Delegate, I applaud you for the bill, first off. I think
you didn't say it about the last one, though.
Well, the last one, I didn't applaud you for that bill. That was a different one. But I hold bills on merits. I'm a good Republican. I can oppose a.
Okay, thanks.
Let me just. I mean, I think that. I got into it now.
Go ahead.
I have had this experience in my home county trying to work through a substantial issue that that relates to the health department's concerns. And let me just say, what I discovered is that there are states like Florida that have provisions that allow for like on-site, we're not talking about septic systems, but like pumping chambers, places where facilities can be cleaned out without having to put a septic system in. There are areas on the Eastern Shore increasingly where we are unable to get a septic system installed. And so we do want economic development. And a lot of these areas, to the ag point, is that there's never going to be these areas you're going to be able to put in septic systems, thus having a farm brewery or whatever the winery is. And so your bill, I think, speaks generally to a very environmentally responsible way to allow some economic development. Because what we're saying is we're going to give you an alternative to putting in a $200,000 septic system, for which, if you were to be honest with MDE, they wouldn't want it to begin with. So, I mean, on that point, I'll just applaud you for the bill. I've been to Kentucky recently, and now look, the big boys have bathrooms, and they've got places to wash your hands and eat dinner and whatever. But there are also these craft distilleries, the small guys, and I got to tell you, what they lined them up with? The porta potties. I mean, as a consumer, I like to do business with the small guys just like I do the big guys, and all you're doing is granting some economic development potential, at the same time trying to negotiate with those that I think in a lot of cases just don't have a good sense as to being reasonable. And I think your bill's very reasonable. Thank you for that.
Thank you. Yeah, the big issue here.
No, not you. There was no question posed, and you've had all the words you're going to get today. In fact, he might have hogged up any words you had left. Let's wait for a question here. That was a very long way of saying you support the bill. Thank you. We're doing great. Delegate Queen.
Thank you, Mr. Chairman. So just for clarity, because I think we talked about this bill a little bit, you want to have a standard, allow the state to say for all the jurisdictions, there is a standard porta potty that could be used in other places. Because we had this conversation, and I talked about what we use in Montgomery County, and that if we, because when people think of porta potties, and they think about this topic that the Mako is saying, some of these are just like going into to a restroom with sink and water and all that stuff. They can be very elaborate. And so they don't have hygiene issues. So you want us to come up with what that standard is and make that apply to all the counties. Is that correct?
Yes. Is that short enough, Mr. Chairman?
And we got a model for you.
Thank you.
Delegate Pittman.
Thank you, Mr. Chair. I'll try to be quick. So current law requires a convenient toilet, separated from any room, and then also method to dry hands. Do the porta potties, can they meet all those requirements?
The big issue that the porta potty, a typical porta potty has one function. Mm-hmm. Then the issue really becomes the pressurized water and being able to wash your hands when you're done. Mm-hmm. And it seems to be there's a tremendous amount of confusion or, lack of common sense on what that washing station should look like. Mm-hmm. You have some side of pressurized water. Well, pressurized water could come from a well, it could come from a spigot, it could come from say a 50-gallon drum where you press your foot on the bottom, it comes out, you wash your hands that way.
Yeah, and they have the porta ones too, that are right next to the porta potties where you just put your foot on a little pedal and then the water, there's a water tank in there or something.
That's correct, but however, health is not real happy about that. They want to have more extensive regulation, and I think that personally, this is what slows down some of these ag tourism businesses from being able to get started because of the onerous burden on them to have not only the porta potty, but also the pressurized water.
So last question, this is a quick one. So if you had a porta potty or a row of porta potties, and then you had that little water station right outside, which is also portable,
yeah.
Is it your thought that even if you had all that the local health folks are like, that's not good enough, even though it could meet the current law?
That's correct.
Okay, and this bill would basically say, look, that will meet the law?
That is correct.
Okay, thank you. Sure.
And we have Delegate Rose. I'm sorry, I think that's good.
Yes. Thank you, Mr. Chair. My question is to you is that I know you want to do these porta potties, but do you have a concern in reference to when we're doing these porta potties that, people would not be let into other bathrooms inside their facility? I mean, you're not saying that these porta potties are elaborate or whatever, but do you think that, is that a concern, maybe?
No, not to me.
It just raised a little question to me, that's all. Thank you.
You're welcome.
Okay.
Thank you, Mr. Chair, and thank you for the bill. Sort of going off of what Jesse, Delegate Pippi was saying. So we had an issue, a pretty major issue in Carroll County with a winery and with the local health department being overly onerous with some of their rules. And so what we found with the numerous problems is that because there is sometimes vagueness within state law, that these health officers can often get very nervous about making a decision and err on the side of being too strict or changing rules or making. So do you think this will help local officers feel comfortable in making a determination that they can stick with? Do you think that will help clear that up?
Yes.
Great, thank you.
I think we have one virtual. Just you. I believe this concludes this hearing. Again, thank you.
Thank you.
Next time we'll have a more abbreviated hearing.
Yes.
Thank you very
You're welcome.
Next, we have Delegate Ruth.
not going to be able to.
I apologize.
I'm Jack Corcoran. I'm her legislative aide. She has both committee today and I think like 3 bill hearings scheduled for all this hour. So I'll be giving her.
I'll say this, normally, if a senator sends over one of the representatives, that we don't hear the bill, but we do make room for delegates, so go ahead. You're good.
Awesome, thank you. So first off, thank you to Chair Wilson and the rest of the members of the Economic Matters Committee. My name is Jack Corcoran. And to just get started, during the last few years under Governor Moore's administration, Maryland has made significant strides in becoming a greener society and a cleaner state. With a variety of cleanup initiatives, Marylanders have picked up tens of thousands of individual pieces of trash, with the most prevalent litter being single-use plastic beverage bottles. Even when these plastics are properly disposed of, landfills and waste incineration disposal, they still remain prohibitively expensive and can be even dangerous, causing air pollution and serious health concerns that disproportionately affect people of color. The state of Maryland contains 36 professional and collegiate athletics facilities, and by allowing reusable beverage containers within the grounds, HB 639 will profoundly cut back on the waste created at these facilities. For example, some Orioles games at Camden Yards can take up to 6.5 hours to clean up after, much of it from single-use plastics. Given that Camden Yards, as of a few years ago, has a stadium policy that allows attendees to bring in their own food within certain size limits and things like being in a clear plastic bag, it makes sense to cut back and extend this policy towards reusable beverage containers, which would prioritize consumer choice. Reusable bottles are becoming increasingly popular. There were $2 billion worth sold in the United States in 2022, up from about 1.5 in 2020. Such a figure represents a massive opportunity for Maryland to reduce its trash outputs during sports games, where people produce tens of thousands of pounds of trash, sometimes daily, when talking about like sports like baseball during the summer. HB 639 would ensure this, requiring owners and operators of these venues to allow attendees to bring reusable beverage containers at sporting events, provided they're empty and within a 24-ounce size limit. Maryland wouldn't be alone in instituting such a policy. In 2024, legislation introduced in New York City, home to some of the most well-attended facilities like Madison Square Garden and Yankee Stadium, went into effect that required stadiums to allow attendees to bring in their own reusable bottles within that same 24-ounce size limit, which is legislation that helped inspire HB 639. Despite concerns regarding security, there have been no occurrences of fans that used bottles as weapons or throwing them on the court since that bill has been introduced in 2024, or I guess enacted in 2024. There have been additional similar policies throughout the country as well. Seattle's Climate Pledge Arena, home to the NHL Seattle Kraken, they allow for fans to bring in their own bottles, provided they're empty, and can be refilled within the stadium using their bottle refill station. In Maryland, Salisbury University allows the same. And in DC, Care First Arena, who they have the Washington Mystics of the WNBA, they allow for attendees to bring in their own reusable container, as well as bottle refill stations throughout the arena to fill their own. It is time for Maryland to not only allow fans the freedom to bring their own bottles into these venues, but also to seize upon the opportunity to significantly cut back on waste and protect our environment. And I urge this committee to issue a favorable report on HB 639. Thank you for your time. And if you have any questions.
Thank you, Mr. Chair, and excellent job presenting the bill on behalf of the delegate. Good job, appreciate it. I love the idea of the bill. I love the idea of making sure that we have, cleaner stadiums, et cetera. A little worried about some of the mechanics of how this would work. I did see some issues with the fiscal note. There'd be a financial impact on enforcement, a financial impact on loss of revenue, which in the situation that we're in isn't the best thing to have right now. But the other question I have is just on safety in regards to not the safety of throwing the bottles, but more so the safety of part of using a reusable, part of using disposable items is also for the safety of disease spreading, or if someone's sick, how does that, have you all thought about that with the bill? I'm thinking about if you're walking in with a cup and you got the flu, you're now, getting beverages, and I'm worried about that part more so than that part of safety. And was there any conversation on that, on how you all plan to contend with that? Some stadiums don't have it where you can just walk up and fill your own, so they have to, take it behind the counter. So I'm just trying to understand how that would work.
Yeah, so first to address the fiscal note concerns, Delegate Ruth is in contact with the University of Maryland College Park, they were the ones that mainly raised their revenue concerns with the fiscal note. She is in communication with them and plans to have a meeting very soon. As far as safety concerns for like disease spreading, there's nothing that we really made note of in like as far as bill research goes about that. I do think having reusable water bottles in line with them in the stadiums would allow for like bottle refill stations to be more popular.
Right, yeah.
Versus traditional water fountains where you're obviously putting your mouth near where someone's else put their mouth, and I think that would be a bigger vector of disease spreading than people having like I don't know what.
So this is only for water. This is only for water.
Yeah, because they would have to be empty when they're brought in, and then they would be refilled in the stadium.
So it wouldn't be, okay, got it.
Yeah.
Okay.
So you can't like fill it up with other stuff. Yeah.
I mean, I like more than water.
Thank you. You were reading so fast.
Sorry about that. I didn't want to take up too much of your time.
No, I understand. But you said, you were talking about the health aspects of the bottles, plastic bottles, even though they may be disposed of properly, and that it could have an adverse effect on the health of Black folks. Can you explain that?
Yes, so it was primarily not, I'm sorry.
I missed that. What was that quote again?
During his testimony, what he was reading, and I said he read so fast, so I may have missed something, that there could be adverse health effects even with the proper disposal of plastic bottles, single-use plastic bottles, an adverse health effect on Blacks. And so I just wanted to. Yes.
Is that a proper quote?
Yeah.
That's okay. So you don't testify. I usually don't. I feel like you're talking about me when I'm in the room. I don't know how. I think we could agree that this would adversely affect white people the same way. And I get kind of nervous because a lot of times I feel people use this almost like as a virtue signal or to pat themselves on the back, meaning there are plenty of Black folks here, and this is not on you, so please take this back to your delegate. That's not really appreciated here unless it is extraordinarily specific, and there are certain instances that it is. But for the most part, we can just talk about people. We don't need to talk about environmental justice. We can just talk about the environment. We don't need to racialize a vast majority of what it is we do here because it's extraordinarily patronizing. And please, I would probably be a little more forceful if it was an elected official. But and to let you know, a lot of African Americans, I'm sure, share this feeling, especially up here, because I often ask people, how are you going to save me if I'm better than you? Sometimes I just need an opportunity and you can move out the way. So I miss that, and I just implore you to take it back to your delegate that when you come, especially to ECM, we do have some racially sensitive topics. Most of them aren't, and they don't need to be made racial. Please, just for my benefit and for the benefit of the people listening, there's plenty of African Americans who can speak for themselves, who can defend themselves, who can articulate for themselves, and we really don't need people, especially people, I don't know how to say it, I don't need white people defending me. I would just appreciate that. And again, if you could just take this back, unless there's something, if we're talking about like, I don't know, a very racially specific disease, which maybe you've got one for me?
No, so it was more so to provide further context that the locations of landfills and the locations of places where this waste is being incinerated are primarily located around predominantly African-American neighborhoods.
But you get my point though, right?
Yes.
There's so many other things we can talk about, and this really isn't on you, so please, it's not well received in the majority of this committee. So thank you again very much.
Yeah.
I'm sorry, Delegate, did you have a question?
I think you handled it.
Okay, thank you. Young man, you did a great job.
Thank you.
I'm sorry for the verbal abuse that you took, but I really do take that very seriously, bud. We have an amazing group of people here of all ethnicities, and we even have Republicans. So I really, so we have a diverse group of people here. And some of them are even good Republicans. Some of my best friends are Republicans. But no. So all that to say, but I really appreciate you coming in and doing that, but it just gets under my skin a little bit. I believe that we have finished our bill hearings for today, right? We have one more?
We got Rogers.
Oh, man. All right, sorry, we do have one more bill hearing. Delegate Rogers, please. Thank you for catching that, Delegate Harris.
Good afternoon, Mr. Chair, and members of the illustrious Economic Matters Committee. For the record, I'm Delegate Mike Rogers, and I'm here to request a favorable report on House Bill 895. House Bill 895 really does two things. It adds uniformed services. So when you say uniformed services, you're talking about the Public Health Service and the National Oceanic Atmospheric Administration, NOAA, to the terminology associated with veteran, and it also more closely aligns the U.S. Code with that of Maryland. There's no opposition to the bill. There's no fiscal note. How's that for an economy of words?
Do you have one virtual, correct? David
Dragons.
Chair Wilson and members of this committee, thank you for the opportunity to testify in favor with amendments of Delegate Rogers' bill. I'm Dave Dragics, retired Army Colonel and Legislative Director for the Maryland Military Coalition. We strongly support this bill's modernization of the Maryland Code, making it consistent with the U.S. Code in using key terms related to the uniformed services and making the use of those terms consistent throughout the Maryland Code without changing policy. This is critical as a lower percentage of our population serves or has served in the uniformed services. 88% of the current 185 members of the Maryland General Assembly have never served in uniform. That's all the more reason to ensure that the usage of these terms in Maryland Code is clear and correct, leaving no opportunity for misinterpretation, and for our position on the term veteran in House Bill 895, which is detailed in our written testimony. Our position is to make certain that those who have served in the Public Health Service and NOAA continue to have the same rights and benefits as those veterans who have served in the armed forces and received a DD Form 214 that is other than dishonorable. Our position is to make certain that all federal, state, and legal references supporting that clearly indicate the same thing to all who will use these references in the future. That is why we've worked with Senator Simonaire on the Senate side and Delegate Rogers on the House side in requesting this amendment to avoid any misuse of the term or misinterpretation of who is a veteran in any future legislation or policy making. So the Maryland Military Coalition strongly supports HB 895 and asks for a favorable with amendment report from this committee. And we would like to thank Delegate Rogers for sponsoring this important legislation and appreciate his leadership on this issue.
Thank you, sir. I don't see any questions for you. Delegate Rogers, I know you'll give us some input on the amendment. Just keep me posted. I do believe that concludes this hearing. Colleagues, we do have another meeting tonight around 6. I look forward to see some of the smiling faces. Thank you guys very much for a great day. Every year somebody feels like they got sick. Was that 2 years? No.